I call the member for Heffron.
Mr Deputy Speaker, I move that notice of motion listed in the business paper as 1084 should be reordered and prioritised for tomorrow. This motion should be debated tomorrow because there are two dead young people, Eliza Wannan and William Dalton-Brown, who were killed by Rhys Colefax on the 27th of January 2010 at Molong, and an Attorney General who refuses to discharge her own lawful duty in accordance with Section 8 of the Criminal Procedure Act. As members opposite know, I do not move such a motion lightly, but when young people are killed in circumstances where it seems to me the question of manslaughter should be considered by a jury, and an Attorney General, when asked, refused to apply her mind to that question, she must stand condemned. It is her fundamental responsibility of her office. It was Australia Day long weekend 2010 when Eliza Wannan and William Dalton-Brown were amongst a group of between 60 and 100 friends from the local area, the majority of whom were between 17 and 19 years of age, many of which had returned to town after completing first year at university, gathered at the shearing sheds of a property in Molong, intending to spend the night. It turned to tragedy when the swag that Eliza and William shared were run over as they were crushed to death by a vehicle driven by Rhys Colefax. A son of a policeman was 17 years of age, unlicensed, to have been drinking. Whilst there is considerable criticism by the media and the deceased family of the police investigation, I make no comment about that. On the 27th of May 2013, a coroner terminated an inquest, referred the matter to the DPP for charges of driving in a manner dangerous, causing death. The DPP declined to prosecute because the death did not occur on a road-related area. Her Honour recommended the law be amended to cover a future eventuality, which the Attorney did. During debate on the bill, I raised the definition of involuntary manslaughter. I told the House of my concern it looks like manslaughter had not been committed and the matter may have slipped through the cracks, expecting the AG to advise that it had. She just said the DPP considered there was insufficient evidence to warrant prosecution for an indictable offence. After giving notice of this motion, I met with the staff of the Attorney. I again raised with them my concern that manslaughter has not been considered. I indicated that if it had been, and I am shown the advice confidentially by the DPP, I would accept it even if I disagreed. Recently I advised that they were not prepared to show it to me confidentially. The only inference I can draw is this is a cover-up. Why else would I not be told manslaughter had been considered by the DPP? Why can't the Solicitor General look at it? There are two dead young people, a grieving family, no one brought to justice, and an Attorney General who refused to discharge her responsibility. This is one of the most reprehensible things I have seen in a lifetime in the criminal justice system.
When did it happen?